Good afternoon, everyone. Good afternoon, audience. Good afternoon, internet. It is revision. We're having Saturday afternoon, and thank you, everyone, for coming to the seminar in spite of the awesome weather. If you didn't see me at your seminar, then I must admit it was because I couldn't go inside. It is just awesome outside. So thank you very much for being here. I'm netpoet. Most of you probably know me and the fact that I do legal stuff. I have for a lot of years. Usually, I used to do these legal things in German because I'm a German lawyer, and most of the time the stuff that I talked about concerned German legal systems and structures. So I'm especially happy to be talking about this topic in English this year for two reasons. Because it concerns probably all of us in this room, and probably everyone watching this too, even outside the EU, and because it is a topic that deeply moves me, has moved me for years and years, and especially in the last, I don't know, 3/4 of a year maybe, because what's coming is obviously the GDPR, meaning an EU regulation regarding data protection. So the General Data Protection Regulation issued by the EU Commission. And I chose this topic because it is very close to reaching force, being actually actively applied, and a lot of people don't know what to do about it, don't know if they have to do anything about it, or what they should do now that they haven't done anything about it. So trick or treat is sort of a provocative question to say, how do you deal with this? Or how do you think you have to deal with this or you don't? Just this morning, I talked to someone who said to me, well, this doesn't concern me. And I go, oh, how so? And he goes, well, I don't, it's only for web shop owners or something, or like, I don't have a web shop. And I go, okay. He goes, well, that doesn't concern me, does it? And I go, yes, it sort of does. So the topic is very frustrating to me too, because I think data protection is extremely important. It is crucial what's happening in the next year, maybe two, for various reasons that we're going to talk about today. And I'm sure that you will have tons of questions when we're done. It's unlikely that I will be able to cover all these questions in this format, but I will be here until Monday, so please don't hesitate, because no one does anyway. Everyone approaches me with questions about this. So please do. A beer helps. But it is something that deeply moves me, so please approach me with questions if you have any. So let's start with what is currently happening, meaning this is, I think, what the legal situation might look to many people right now. It's in turmoil. There's tons of shit in there that shouldn't be there. What's going, like, how does this fit together? It's just, the world is in turmoil as far as I can see with regards to the legal situation. So what are we going to look at today? I would like to talk to you about what the biggest hurdles for companies are, like what do you have to do if you have a software, if you manufacture software, if you want to buy a software or rent a software, like cloud services especially. What is going to happen legally, and as far as I can do that, with regards to who is going to sue for what the authorities are going to do, which is basically two big sectors, and why all this is going to happen. And I cannot spare you, and I think it's actually quite interesting, a deeper look at what's in the GDPR. What is this? What is going to change? Hands up if you have at least seen the GDPR in full text. Okay, a few, okay. So if you have, you know that it's quite long. And just as a general tip, whenever you look at an EU regulation or a directive, there are reasons at the beginning. So in the GDPR, it's sort of 40% of the entire full text. It's basically just reasoning behind all this. And if you think, why on earth do they need reasoning if the regulation doesn't speak for itself? Isn't it, like, what's wrong? What's wrong with you, EU Commission? It's very helpful to sometimes look at reasoning behind all this. So it's actually not bad to have that. So, to roughly summarize this, and I know especially if you talk to, there's a lot of webinars out there, a lot of people talk about the GDPR and what's happening, and some say, oh, it's not all that strict and nothing's going to change. Essentially, nothing changes. People go, oh, the exact opposite. I've heard pretty much all opinions about what's going to change and how strict and how bad it'll be. And to be quite honest, I don't really know how bad it'll be in practice, but there are 5 sentences that I think summarize the GDPR quite well, in my opinion. First of all, fines have leveled up dramatically, meaning if the authorities catch you in the future with a violation of any duty that you have according to the GDPR, the fines will be much higher than they used to be. I'll comment on that too. But the fines have leveled up, which, by the way, is, I think, the primary and maybe even only reason that a lot of people pay attention to this now. Because GDPR isn't actually reinventing data protection from scratch. It isn't. It's a lot of things stay pretty much the way they are, even now. And from a German perspective now, it makes perfect sense because 2 people who worked on this, on the actual text of the regulation, are Germans and lawyers. So in some regard, it's not exactly true, but in some regard, you basically took the German Data Protection Act, you translated it into English, then you translated it back into German, and you modernized a few things, and then you have the GDPR. So it's not like data protection is reinvented from scratch. It just isn't. A lot of details change, but it's not like we're getting a completely different data protection altogether. If you have been data protection compliant until now, or at least somewhat, then chances are that you won't have to do much in order to stay compliant or to stay fine-free, if you will. Also, we remain with the basic rule of preventive ban subject to permit, meaning as opposed to the general freedom that we all savor here, meaning we may do pretty much anything we want unless there is a law that forbids it or other people's basic rights, then we may do whatever we want. In data protection, it is exactly the opposite, meaning unless you find a law, a provision that states that you may do something, you may not. So that basic rules. And number 4 is we're doing all this because we want to unify data protection within the EU. For many small companies in a certain country, it doesn't make much difference now, unless, other than that you have a new legal situation now. But especially the international corporations complained, I think rightfully so, that in Germany you would have a different level than in Spain, than in Portugal, than in Poland, than in France, and anywhere. So for what it's worth, it is a good way to unify data protection within the EU. And that is also one of the major focuses of the GDPR. Data subjects are supposed to be able to enforce their rights better, meaning they should be more in the center of the whole regulation, meaning they need to know what's going on with their data, and they are supposed to be allowed and entitled to decide what type of data they want processed by anyone or not. So that's basically we're done, you can go now. A word on fines, because that is something that everyone is talking about, like the fines, and you've probably heard it, like the 4% of the net sales volume worldwide, or 20 million euros, whichever is higher, is the absolute maximum amount of a fine. So that's a lot. And also, keep in mind that you could have several violations that could theoretically add up. So obviously, it can become really expensive if you violate something. And the article, whenever I don't give a special reference, and I think there are none in this presentation. Whenever you see an article, it's always a GDPR. If you want to look it up, it's everywhere. You can find it. Or if you have this presentation, you can click on it too. So Article 83 says fines have to be effective, proportionate, and dissuasive, meaning they have to be high enough so that people don't violate the law, in principle. But in Article 58, you'll see that fines are only one means of measures that authoritative bodies have. They have all sorts of powers, and they're basically divided into three sections, meaning investigative, corrective, and advisory. And as much as that probably theoretically makes sense, that means that authorities can do all sorts of things. They can also, instead of fining you, just tell you to stop doing something and like using a certain service, for example. But it also comes with this. What many people don't understand is that with these powers come duties and obligations, meaning authorities have to do a lot of things as of May 25th this year. Meaning that depending on how, let's say, how greatly understaffed a certain authority is, these new powers bring obligations, and someone has to do all this. So I think it is no secret to say that a lot of authorities have no idea how to deal with all this. The whole advisory thing comes into play, for example, if any data protection officer or any company approaches an authority saying, hey, we're trying to get this and this working, is this okay? Is this data compliant to you or not? Are there any specific measures that you would recommend us to take or something? So basically, and I'm not suggesting that you should do this, but if you wanted to, like the whole Article 58 with all the obligations that come along with it and the powers that authorities have, it is very well possible to act upon a really, really powerful distributed denial of service attack. Drowning them in work. A lot of authorities have no idea whether by May 25th this year they will be drowning in work or have nothing to do or something in between or how much staff they need. And you know, this is a very political issue because they need new staff, and it's not all that easy for every authority to get it. Now, just if you are a CEO or if you report to a CEO, you might think, why are CEOs acting upon this now? Like, why is this important? Why should they care? And there are a couple of options that I can think of. One of which is obviously personal liability. Now, this is a very German thing, but I assume it's kind of the same in many countries. If you have a provision like this, like the Limited Liability Companies Act, like the GmbH-Gesetz or the Aktiengesetz, it means whenever a CEO neglects a certain duty, he or she might be personally liable, meaning whenever you get a fine of a couple of €1,000 or maybe a couple of million even, it might stick with the CEO. They don't want that. Second, you just risk a fine. I mean, you lead a company and you obviously, I would assume naturally you wouldn't want the company to be fined. And also, some companies use this whole thing as a trust factor, like a USP, saying our software is GDPR compliant, things like that. So those are three reasons that I can think of why you would start doing something. Now, what is the GDPR formally? Meaning we're not looking at the content yet, but we're looking at what this is. Like, what did the EU Commission do? What does this do with what power does the GDPR have? Now, and this is really important because someone, like last night, someone talked to me about it and said, oh, like directive, regulation, like words, and I said, no, there's a substantial difference. Whenever you have a regulation coming from the EU, it means it's directly applicable. Like there's no National Transcription Act, nothing. Once it steps into force, this is your law. Like, I mean, unless it's not applicable to you, but anyone in the EU and many people outside the EU have to listen to this now, including, by the way, like people like Google or like companies who have no residence in the EU but process data from people inside the EU. So, so this is applicable to very many countries, meaning which also results in odd stuff, odd symptoms. Like colleagues of mine travel to, I don't know, Thailand to have GDPR talks, and at first you'd go, why Thailand? Well, because some of them offer services that process data of people inside the EU. So regulation meaning it's directly applicable, as opposed to directives, meaning, for example, like the Data Protection Directive from '95 that is now going out of force, that is regulating things, and it's directed towards the member states also, like Germany, so that the nations have to put this into German law, like the German Data Protection Act, and I'm sure there's all sorts of things everywhere in the EU. And there are certain things in the GDPR that are so national, like so nation-specific, that the Commission didn't dare to touch it. For example, when you have to appoint a data protection officer, in Germany, for example, that means that is usually the case whenever you have 10 or more people in the company who are entrusted with automatic data processing, which is everyone, basically. So if your company is sort of around 10 people, you probably need a DPO. Or how to handle data protection in employment situations whenever you have a subordinate relationship, meaning how much of free will is a consent declaration. That is also subject to national provisions, and how you handle related crimes. So there are certain consequences that can arise from a data protection violations, but everything that deals with a criminal court, at least in Germany, is dealt by or is provided by a German new Data Protection Act. But these things are still nation-specific because that's something that the EU Commission didn't have the power to regulate. And also, just as you, oh, that's a nice format. Just so you know, this has nothing to do with the e-privacy directive or the e-privacy regulation that's about to come. There's much discussion about like how the two are related, or what's going to happen in what state. This is not part of the talk today, but the e-privacy regulation / directive is a different thing, not altogether, but the GDPR does not replace the e-privacy directive, but the e-privacy regulation will do that. It's very often the case that the EU starts with a directive, meaning we have certain standards that we want nations to abide to, and then whenever you go, okay, it's still not unified enough, they pour all that into a regulation. Now, what's inside the regulation? The GDPR means to strengthen data subjects' right. I said that in the beginning, meaning they need to have transparency of what type of data of theirs is collected, processed, used, stored, etc. And also, they get new rights. They have basically the same rights as before, plus a few new ones, including this right to lodge a complaint, or, and this is something that's going to shake up quite a few nations, I think, a right to sue for immaterial damages. That's something that's almost unknown. I'll get to that in a few minutes. But these are things that the GDPR wants to do. And also, as the fines rise, we get more severe consequences for violations. Also, and this is just like more on a formal structure level, looking at the EU, as we unify things, we also have to make sure, or they have to make sure, that the authorities involved in certain cases, especially when you have international corporations and you have a violation that might, influence or concern several countries, you have to sort of figure out how the authorities can cooperate, and also who leads and who, like, how to cohere with these things. Also, there's going to be a European Data Protection Board, the EDPB, that will handle a lot of things that are escalated. Whenever you have two authorities that can't really make up their mind, it's ultimately, if they cannot come to a conclusion, it's going to end up at the EDPB. And the biggest new complexes are based for companies. And if you're wondering what to do, I'll get to that in a moment too, but the biggest new duty complexes are giving information to data subjects, because if you don't do that, they cannot transparently know what you do. And there's a certain more formal cooperation or correspondence with the authorities demanded, meaning especially if you have a violation of data protection, something like not everything, but something substantial, you have to report it to the authorities. So that's basically what the GDPR is aiming for. And I now have a list of things, and now this is going to be really general, and we could talk probably about each and every of these points for days, because a lot of questions arise around these things as the realization of all this in practice can be very, very difficult. But just so you have an idea, this is just an excerpt, but so you have an idea what's going on and what's changing. First of all, and this I've already alluded to, it's applicable whenever you have data of persons in the EU, processed, collected, something, regardless of where the processor resides. It can be outside of the EU, doesn't matter. Also, we get new information duties to fulfill our duties towards transparency. If you want to look that up, it'll be Articles 12, 13, and 14, meaning you have to give all sorts of information, which, by the way, that is one of the things that I like and dislike at the same time, because certain things are very difficult to do. You have to give a lot of information on like what type of data you need and what you need it for and the legal basis for all this. And if you think it's difficult online to do that, that is true sometimes, but then just think of a phone call. Like you call your doctor's medical office and you want to make an appointment because, I don't know, you have a flu or you need a shot, or I don't know, it still itches after you washed. The types of information that they have to provide to you before you can actually give them information and, you know, all sorts of things, it's to some degree, sometimes it can almost be absurd. Just there's something that has to happen at some point, but it's good in principle, but in practice, I'm not quite sure how to do that sometimes. And also, the requirements to get the consent from data subjects are stricter. Meaning, especially, and this is important, especially to those of you who think that these things, like these consent declarations, these texts, have to sound like a lawyer made them. If that is the case, that is the case already, but if that is the case under the GDPR, you're doing it wrong. You have to use clear, plain language, which in theory sounds really good, because you want people to understand, and it's natural. I mean, if you want just the everyday guy on the street to understand, it's not all that easy to do unless you use clear, plain language. However, with all these informations that you have to, with all this information you have to give, the sheer amount of declaration and text that you have to give him, I think, is not only difficult to get, but in the long run, and I'm not quite sure how long we're talking, but in the long run, I think will only emphasize the symptom that probably all of us already know. Whenever you go to a website and you get the cookies disclaimer, I'm not quite sure. Has any of you hands up if you've read the actual all information that you get when you at least once that you click on? Okay, so some. But would you agree? I think it's in most cases something that we've educated people to basically click away, because we're giving them so much stuff to read. Just yesterday, someone told me that a certain like updating process didn't work because most of the users thought it was something that they just had to click away, and it didn't work for some reason. So we're basically educating everyone with the sheer amount of text that you have to give them to click stuff away. And because, you know, I don't have time for this, or I don't like to deal with this. So that's actually one of the things that I think will be crucial in the future, to see how people really deal with the amount of information that you're supposed to give them and they don't really want. But anyway. And new, I already alluded to that, you have a new right to lodge a complaint with the authorities, and people on all the data protection information on websites and all, you have to tell them that they have that right. And this is one of the cores that most companies are struggling with at this point, unless they don't have any access to personal information, which is not many. The data subjects have pretty much the same rights, apart from the lodging the complaint, that's new, but they have the same rights as before, rights to access to their data, rectification if it's wrong, and erasure, meaning the right to be forgotten. And you have to provide them all that information. That alone is a problem. I'll get to that in a moment. Also, they have the right to data portability, so the data that they provided to a certain service or provider, or that has to be able to, they have to be able to get it out in a machine-readable format, which sounds good, but don't confuse it with interoperability. So I think it's obvious, but just to say obvious things once. You're not entitled to go to Facebook and say, I want all my personal data, get it out, and then go to, I don't know, Google Plus and say, hey, I'm uploading this and I want everything to work the same way Facebook did. That obviously cannot be the case. And I'm not quite sure what they're really trying to achieve with this, because having it in a machine-readable format, given, fine, I get it, it's good, but what then? Like the majority of people are supposed to write their own services to use the data or something, or to interpret. I think it's good in theory, but not quite sure how that's going to be. Nando.
I think it's a good way for insurances to share data for customers for criminal detection.
Nando just said it might be a good way for insurances to share. I'm not quite sure that works. Share information among themselves about customers, about cases that they had. Okay, just don't confuse this. It's not about, like, you as a data subject are entitled to get the data out. You could give it to someone else. But it's not like the two insurances are allowed to exchange data unless, of course, you consent to it, which has to be clear and plain and all. It might make certain things easier, right? You're right, like a medical record or something for insurance.
I think in the future,
wait, okay, microphone, microphone.
Thanks. I think in the future, if a company, I ask my new customer for data format from his privacy person, and so I have the ability to check a lot of other companies where the data also stored.
I'm not quite sure where you're going with this.
It's an easier way to
You can say it in German too, I'll translate.
Also, mein Punkt ist, wenn ich jetzt, ich verlange von meinem Kunden, der zu mir kommt, zum Beispiel er möchte ein Auto zulassen, verlange ich von ihm sozusagen seine gesamten Schadensberichte, die er offenlegen muss, um eine Versicherung abzuschließen. Dann kann ich mit seinem maschinenlesbaren Format relativ schnell alle anderen Punkte mit abchecken und natürlich besser kalkulieren oder auch vergleichen, ob er die Wahrheit sagt und.
Okay, so
ganz kurz zum Beispiel, ein guter Punkt wäre zum Beispiel das polizeiliche Führungszeugnis.
Yeah, okay. So Nando is saying that if you get all your information from a certain provider, like an insurance or any type of service, then it might make concluding new contracts with, for example, a different insurance or a different service easier, because this service would require you to upload for example, your record of damage or any sort of incident history. It might make that much easier and more convenient, which ironically I think would completely reverse the whole idea, because it would make you much more transparent to the service providers, as opposed to, you know, making it easier for you to get information out. But yeah, let's watch out. That might actually be a side effect that we don't want, but they do. But the question is whether it's allowed to force customers, to require customers to upload certain data. In principle, yes, it is. You could, I mean, not in all cases, but in principle, it is possible to ask you to say, I need your record in order to provide services. If you don't want me to get this information, then don't be a customer. 'Cause, I mean, Facebook basically does the same stuff. It's a little different because there is no major service in the foreground, but it is, in theory, there are certain limits, but in theory it is, in principle it is possible to do that. Now, access to personal data, just so that we know what we're talking about. I'm quoting Article 4, paragraph 1 here. Personal data means any information relating to an identifiable natural person, meaning we're not talking about companies' data. Everything that relates to a company is not relevant to data protection at all whatsoever. Natural persons. And identifiable they are, even when they're indirectly identifiable by, for example, an online identifier, meaning a cookie ID. So basically everything. And when you can relate to a certain natural person, even by a cookie ID, then we're talking personal data here. Now, the right to access means that any natural person can ask you, can require access to any and all of their data stored with you. Now, as many of you are software developers, I think you know quite clearly what that means. You have, first of all, and this is not where it ends, this is sort of where it begins. Software needs to be able in the future, I mean, it's not a must, but it's almost a must. So the software that you run must be able to gather all relevant data sets of a certain natural person, ideally automatically. Then, first of all, a problem can be that you don't have enough people to deal with these requests. That is also one type of DDoS attack that you can run on a company. And there are people, there are a lot of people and sort of associations, and I'm not criticizing, I'm just saying that there are associations who enforce this and encourage people to do that. And I think it is important to some degree, but they will have forms that you can just fill out and send a request almost automatically to any sort of company or a specific company if they want to give them extra work, and because they don't have work already. So a problem can be for companies to just not have people to deal with these requests. Also, and this is also major, and Andre, we talked about this in our last legal bits issue, and we talked about CRM, like customer relationship management, in coherence with data protection and GDPR and how that works. The cross-references can be critical. If you find data sets that relate to a certain natural person, then quite often, depending on your business model, you'll have personal data on other people as well, just because the set is laid out that way. Someone, I don't know, added a certain text field, like it's a string, and it has other names in it as well. What do you do then? It's quite difficult to separate the things at places where you have to. Ideally, automatically. How do you do that? You cannot. It's a layer 8 problem most of the case, because the best software cannot prevent idiots from using it. But that is a problem for for larger corporations especially. And as if that wasn't enough of a problem, you have the problem that identifying a certain request, a person requesting something, is difficult enough already. If you get an email saying, hey, I want my data, and you have sort of an email address and you could think of someone who could be that, how do you make sure that you actually give the information to the right person? I'm not going into detail, but I'm saying that alone is a problem. And if you have larger corporations, I'm sure a lot of people in this room do, or in the internet, you know what I'm talking about. If you have a larger corporation, then they usually have completely shattered IT infrastructure. They have more than a dozen systems processing personal data, sometimes half double, and you don't really know the hierarchy, like what's the master system, and if you have different records, and what do you do, and who rectifies whom. That can be quite a task. So a lot of companies now, as you can probably figure out by now, are working quite hard to get their system, their structure well enough figured out so that they can actually find certain data sets, rectify data everywhere, get them out, get an XML file or a JSON file or something, and give people access to their data, or delete stuff and things like that. Now, let's go back to the changes. There are a few other things. Privacy has to be default in design, so you're supposed to create systems that are usable with as little personal data as possible. However, that is supposed to work with online trackers that track by default. I don't know. The legal text says that shouldn't happen, but I'm sure that the EU Commission didn't want to kill all the industry. Whenever you have a data commissioner, meaning another person processing data for you, that changes dramatically too, because I always say they sort of grow up and they have to correspond with the authorities too and all that stuff. Also now, unified is the data protection impact assessment. That is something that companies have to do whenever they want to change something major, like introduce a new system, like a customer relationship management system or an HR system or something that relates to a lot of personal data, then they usually have to basically do a lot of paperwork saying the risks are, the measures that we take are, therefore we conclude that this and this is legal for that reason, or it isn't. Authorities want to see those DPIA documents often when they audit. And I already said that if you become aware, whatever that means, but if you become aware of a data protection violation, you need to contact the authorities within 72 hours. So not anytime you think, oh, something is happening, that is not becoming aware, but once you know that something has happened, you've become aware of it, you need to act upon it, and the fines I've already mentioned. Now, this is one of the things that I would rather not have happen, but it's very likely that it will. If this is, and what I'm relating to is a very German thing, but I'm sure many of you have heard of this. In Germany, there have been waves of file sharing, cease and desist letters, and a lot of basically it's basically a very scalable way of making money for using BitTorrent for illegal purposes. And now, I'm not quite sure if any of you is, who's familiar with the name Stella Liebeck? Okay, yeah, we talked about it. Okay, but like, who of you is familiar with the McDonald's grandmother, like with the coffee? Okay, so old story, lady drives through a McDonald's I think in California, I wasn't quite sure, it's been, I don't know what, 20 years. Apparently, allegedly, the coffee was so hot, she put it between her legs and got badly burned. She got a lot of money for reasons. And I think we're doing one step towards it now by having this. in the future, according to GDPR, people will be entitled to sue for material. That's the status quo. That's if you have any financial damage from a breach of your data protection, you can sue, obviously. But in the future, you will also be entitled to do that for non-material damage. That is going to be, you'll have the right to receive compensation, meaning you'll be able to sue for non-material damage. And that will probably produce a league of lawyers to have another way of finding a very well scalable system to sue and make a lot of money. I'm not saying I like it, I'm saying I dislike it, because that is a side effect that shouldn't be, even though I theoretically think it's a good idea to have people entitled for things. But anyway, how much is it worth? I don't know, but that is going to have a lobby and a mass sue, like company mass suing side effect, just saying. Now, what do you do if you're not compliant by May 25th? This is what's probably going to happen. You will, if you have access to data subjects' personal data, you will probably be concerned with requests of access to their data. And there will be, as I said, alluded to, there will be associations that make it much easier, distributed denial of service attack, things like that. Authorities might inquire your company, might audit and follow up with all sorts of actions. It's a case-by-case thing, obviously. And just so you know, you won't always be fined. I've seen many cases where people weren't fined, they just said, you have to stop doing that. So in many cases, it's okay to approach a certain business model or a certain service with the idea that you might be able to stop it at once if you need to. Like, just the only thing that I think you shouldn't do is you should base your whole business model on a data protection violation. That is not a good idea, unless you don't give a shit and you're on the Bahamas or something. As I said, authorities are already understaffed. It's not, I'm very uncertain how serious the threat of being fined or inquired by an authority is going to be, but you should be ready, especially if you are noticeable or your company is noticeable in public. And the European Data Protection Board will make a lot of things probably more unified, but their role is not quite fixed yet either. So it'll be a matter of figuring out in the upcoming years what's going to happen. Now, and this is just another information for you, another piece of information. Germany is one of the exceptions in the EU where every state has its own authority. So Saarbrücken is in Saarland, which means the competent body for this would be the Saarland Data Protection Authority, and there are a few countries, and I think Belgium is one of them too, but I'm not quite sure. But that's one of the exceptions. So we basically have the state ones, we have a federal one, and then we have the European Data Protection Authority as well. So it's quite difficult to predict what's going to happen, but it's quite interesting to me. So I'll keep my eyes open. Let's see, maybe next year I can give a quick update or something. Now, what should companies do? First of all, I would say get the visible things straight, like a data protection statement on your website and your apps. Just stuff that people see. If they see that you're not up to date, it's quite easy to follow up on it. Also, whenever you need or want people's consent to anything, say it clearly and in plain language. Say what you want, and if you also give them a link to their data protection statement to say all the information can be read here. Here's a quick summary of what we want. Say yes or no. If you need a data protection officer, obviously, then you should appoint it, because that's something that people figure out easily too. And get your documentation straight. This is the pain for many companies. A lot of companies do really good work, but the problem with audits is that they don't have any documentation on anything. So if someone asks, well, what if this happened, and like if for example this happened, when would you notice it, and do you have any process for it? In many cases, companies do really good work, but they have no paper to prove it. And I know paperwork can be quite tiresome at times, especially if you have actual work to do. In my case, it's the same, but but if you like, this is keeping a lot of people from work, which is unfortunate, obviously, but getting documentation on stuff is really, really important, especially for larger companies. Correspond with the authorities. I think that's already mentioned. Now, to come to my conclusion, is the GDPR greatly overrated? And this is completely a matter of opinion. I would think you need to keep in mind that authorities now face a struggle for their authority too, meaning if you are a data protection authority at this point and you get all these new powers, there's not much you can do other than you actually have to take power and step into action and do something. Because if now we're at this point where when an authority doesn't really do their job, where is data protection going to go? And now this is almost a philosophical question. I get it. That's why it's really important to me and frustrating at the same time, because there's turmoil on so many levels that I also don't know what's going to happen. But keep in mind that authorities also need to prove their point now and put their foot down. I think now with the GDPR, we are at a crucial point with data protection. If we don't do that now, I'm not quite sure how to educate everyone to be sovereign with the way they deal with their own information. Now what's going to happen is many people will request access to their data. I recently read an article about a journalist asking all her data from Tinder. And she said she was amazed by the stuff that she had forgotten, but Tinder hadn't. All the failed blind dates stuff, and we also have to be aware that especially now with Facebook, it'll be really easy in a couple of years, and I think we're going to see that. It'll be easy in a couple of years to see cases where you would want a certain insurance, or you would want a certain, financial backup for your house, and the insurance company or the bank will approach Facebook and look at the people that you talk to, all the metadata. They don't have to know what you said. They don't give a shit. But it's the metadata, the people that you know, the people that you talk to, where you live, where your people live, all that gives so much information on your financial stability. And we just need I'm not trying to be paranoid or anything. I'm just saying that the data that we have now, all the data that's collected, is something that people will use for one purpose or another. And I'm not saying against anyone. It's just, there's no for or against. It's just a certain perspective. If you have data, and I'm sure all of you are aware of that, then it's quite easy to use it for whatever purpose you need. And if you don't have enough data, then you get more data. And at some point you will be at a point where you can make pretty reliable, pretty solid statements on financial backgrounds, health situation, even what you eat, how much money you have for grocery shopping, or the movies that you see or like, or whether you are deeply disturbed, things like that. So people have to basically grow up with all the information that you get from Tinder, from Facebook, from everywhere. How do we deal with this? How do we become more sovereign with the information that we get from people? How do we deal with this? Because I'm sort of convinced that all this information will create a lot of work. Distributed denial of service in some cases, sometimes there will be fines, and I think the first substantial fines towards companies we will see at the end of this year. End of 2018, I think you'll see the first substantial fines being issued by authorities to probably larger corporations, but regardless. And how do we, I think it's going to go away too, to some degree. People will go, oh, Tinder knows all this stuff about me, or Facebook knows all this stuff. This whole thing that happened to Facebook now recently, you know, with the, what was the name of the Cambridge Analytica, right. That is going, I think the discussion is very important, but it's led to a very, it's led in the complete wrong way, I think. But anyway, I think people have to grow up and learn how to deal with the masses of information that there is, that there are about them, and how to work with what we have and how to go from here, because it is I think, a very, very crucial step towards data protection and what we do with it. Thanks. Now, I have a few new stickers if you haven't seen them yet. New stickers, this is for my podcast that I do with Volker, a friend of mine from Frankfurt who works for Google as a network administrator. The access card that you see here, it is really cool because you can pull it out exactly like that. It was, it's Oni of Pooh Brain, thank you very much. You're awesome. Just awesome. And if you want one of these again, because a lot of people asked me to get the Better Thank Frank stickers again reprinted, I did. They're all at the info desk. I have many more. If they're empty for some reason, come up to me. Now, questions. If we still have time. How much time do we have? Oh, none.
Okay, just a quick question, because already now we have some definition for information crimes that if the company misuses or cross negligence or whatever the legal term is.
Mm-hmm.
So when is kind of the violations in relation to GDPR move into that they fit the criteria of the already existing information crimes, and could there be a possibility that you're sort of double accused, that whatever the crime you're doing, it already fits the information crime and it also violates the GDPR? So
yes, it is possible.
Yeah.
That is something that is not actually changing quite a bit. So I didn't go into detail about this, but there are basically three scenarios that you have to face with regards to data protection. One is the authorities and the fines. It has nothing to do with crime. There's no judge involved. It's just the authorities. In German, we call that an Ordnungswidrigkeit. Not quite sure how to call that in English, but it's not a crime. It's sort of like a para-crime or something. It's just what the authorities do. Then you have the criminal system in every nation. That is something in the respective criminal acts. And then you have the natural persons going to court because of their, access or requests to access to data are not dealt with in a right way or something. I'm not quite sure if that answered your question, but these three things can be completely parallel, has nothing to do with it. One is a fine, one is a crime that you have to pay a certain penalty, and then it can be material or a non-material damage that you have to pay.
Okay, which data exactly do the company have to give to the customer if they ask? Only the metadata when you interact with a website, for example, and you click on I'm friend with him or I like this, or even the things which the company processes out of these data,
all
like putting it into neural networks.
Neural networks. I think it's the latter. Everything that relates to a natural person that you store or you process because of that reason, and I assume you don't want to have this extra information without the relation to that person. Anything that you come up with, not only the things that the person sort of provides to you, but also what you generate about them. It's substantial. It's difficult.
So what if I save data to a natural person and then this person deletes their account and I delete the connection to this legal person saying ID 12345 has this data. I delete the account 12345 but I still have the data to this number, which now doesn't have a connection to this legal natural person anymore. Do I have to delete this data, or what's with these data?
You need to delete the personal data. So if you make it anonymous, that's fine, as long as you cannot reestablish it. I mean, sometimes just don't use an ID that you could resolve again easily. If the relationship to that person is gone, like for good, you're okay.
Okay, it's easy to see the small person, the individual who has the rights, and to see the large corporations like Facebook who have the obligations here. But there are other constellations, like in the demo scene we have several databases that we maintain as a community, documenting, striving for historical accuracy going back many years.
Yeah.
Are these now illegal? Could you comment on that?
I have talked about that last night too. I don't know how to deal with that. It's legally you have to delete it. If someone approaches you and says, I want all my records gone, yes, the scenario that you paint is I think that's exactly what you need to do. And I also deeply dislike that you have to, drill holes into this coherent system. And it becomes even more difficult if you have comments on stuff. Like all of a sudden people respond to a comment that you cannot put anywhere anymore. I was thinking of whether the GDPR would even applicable, because it is not applicable in the, I'm not quite sure how to call it in English, im familiären Umfeld. So meaning if you do it in a familial environment, that would be, the GDPR wouldn't even be applicable. But it's very unlikely that that option is open, because as soon as you put it online, public, that area is gone altogether. So the only way to probably get that option is if you had to log in in order to see anything. So that way you could maybe circumvent it, but it's not a solution that I think would be ideal, but it might be better than nothing.
And could one claim that this is only documenting public information and therefore no longer personal information?
There is no contradiction between public and personal. Personal is not private or intimate or anything. It's personal when it relates to, or when there's a natural person identifiable. It has nothing to do with the fact whether it's public or not. I think. Do we have one more question, or should?
One more?
Yeah, one more question,
This
and
is
then everything else. Yeah, I'll be here. It's just so that the internet can do other stuff.
This is about providing cloud services. If we contract a cloud service that, we've been tracking packages, they leave the EU and go to the US. But these cloud services are now self-declaring they are part of a EU-US privacy shield,
Yeah.
and therefore they're complying with GDPR.
Mm-hmm.
However, let's say we use it and we allow our students to upload and our staff to upload personal data, and then they have a breach. Does the responsibility then lie with us who have a contract with that cloud service?
Yes. The question is, who is responsible for violations when you have a data commissioner?
Yes.
Like, is it you or is it the commissioner that you hire? It is you. I didn't talk about that area at all today, but when you hire a data commissioner, the responsibilities it's not even that easy. But whenever you hire someone to do something as you tell them, provide a service and only that service, and you don't have any decision, like no way of deciding what to do with what data, they just have a service and you use that service and they do exactly as you want, then you have a data commissioning situation, and in that case you are responsible because you have to select your commissioner diligently, and you have to survey them and you have to control them, and if there's anything happening, then it is in theory you are responsible for all that. It doesn't mean that you will be highly fined. Of course, if let's say you have a situation where an authority audits you and or something happens and it gets public and the authorities approach you and say, oh, how could that happen? And they audit you and they go, ooh, you're a commissioner, no, and something, and it is your fault. It could still mean that you did everything you could in order to select it and to control it. If basically they fucked up badly, then it's unlikely that you will be fined, at least substantially, but they might still request you to stop working with them. So that's a scenario that could happen. Could we take the other questions outside? Is that fine? Oh, we have time.
Oh.
Okay.
Yes. How do you see the development in distributed ledgers with there's no actual legal entity behind them necessarily? It's immutable. You can't change data once it becomes public.
It is not. The GDPR wasn't meant with distributed ledgers in mind. And I think Andre would probably be in an almost better position to talk about this. You probably heard about the whole child porn thing, right? This one image that was put into a blockchain and you can't remove it. No. I don't know how to deal with that other than blockchains altogether are not GDPR compliant. If you cannot remove personal information, and there is personal information in the blockchain or at any distributed ledger, I think that's what you're referring to, isn't it?
But doesn't it require there to be a legal entity behind it?
The question is whether it's where it requires a legal entity behind it. No. Well, who's responsible for a distributed ledger? Yeah, well, time will tell is an answer I strongly dislike giving because, but the question would be who is responsible for this ledger, and it's probably going to be everyone contributing because you cannot point at anyone specifically saying this is your ledger. Unless, it's a private one and let's say a bank or something does it, then in that case, yes. But like who's responsible legally for blockchains? No. I have no answer as to how to work with blockchains with regards to GDPR.
But frankly, everyone who's, at least from a digital identity perspective, talking about this kind of stuff storing in the blockchain will always object to putting personally identifiable information
Okay.
in the blockchain.
Well,
It will always be off ledger.
Okay.
Recommending to do stuff with it will never propose to put data on that.
Yeah. So the input is that anyone responsible for anyone administering a distributed ledger will always strongly discourage people from putting personal information in there, but that doesn't really solve the problem. It'll try to avoid the problem, but once you have it, I would even have difficulty pointing out the responsible person. So I have no answer to that, I must admit. I don't really know how to deal with that, because if there is personal information in there, you would have to get it. You would have to be able to get it out. So, what are your options? Either be incompliant or fork out anytime anything happens. It would be blockchain in turmoil. It would be the whole system. I think that's one of the things that we will see changing about the GDPR to some degree, or you must be able to. I'm not technically educated enough to know what would be necessary to get, to fork out or to get certain information out. But as far as I know, there is no way to get it out. Not even to pseudonymize it, meaning pseudonymize it. I think. So the consequence would be to prohibit using distributed ledgers altogether, which I don't really want to see happening, but who cares what I want? I don't know how to practically deal with that yet, and I think the authorities also don't, which means how likely is it that you'll be fined for using it? Not so much, I think. What? What was that?
Yes, another question that might be relevant for a lot of people that sit in this audience. I think many of us are working either as freelancers or with companies that process other people's data for their clients, so not for their own company directly. I guess from the question before, it wasn't really clear, is there like a secondary liability if something is fucked up? And the second part of this question, is there some concrete examples or tips that you would give freelancers or companies that, for example, have data in let's say, Amazon's cloud, for example, of natural persons?
If you are a data commissioner, meaning you process data on behalf of someone else, they use your service, or you do certain things, you process data in some regard, or you do something with the data, then according to GDPR, you will very likely need a contract in writing with with the responsible company. Technically, like if you look at it specifically, it is their job to ask for it. However, I have been quite busy creating all these contract templates for companies, for providers like those that you talked about, because it is much easier in practice to have your own template that suits the stuff that you do. Then it's much easier than waiting for something general that no one really knows anything about and doesn't really suit your service or anything. But it is their responsibility to get you on board contractually. So basically, I mean, my recommendation would be to have documentation ready that will have like a data protection agreement and a list of measures that you take in order to protect data, meaning all sorts of things from like access barriers to servers to password protection, using ticketing systems to get Weisungen, how do you call that in English? Specific orders in and out, how to track that you did it or what you did, and all sorts of things. So get your documentation ready, basically, a contract. I would have a contract template ready that you can submit to them saying, I'm aware of the issue, and also so that you can conclude that and get it out of the way. Also, I didn't really go into detail here at all, but if you are a data commissioner, in the future you have an obligation to say to tell your client when you think that you process personal data for them. So until now, you could always sort of say, hey, I only do as I'm told, I have no way of deciding, but you have an obligation in the future to say, hey, I have personal data here, don't you want, like, that should be handled contractually at least. But and I mean, apart from the usual stuff, whenever you get data outside of the EU, watch out. Whenever you use services, especially in the US, look out for that EU-US privacy shield. I don't highly regard that, but on paper, and the authorities say it's fine for now. So that is something to watch out for. And just be aware in general what type of information is processed and transmitted to whom, for what purposes, what they do with it. That's always a good thing to do. In practice, there are many things that you have to watch out for, but that is usually what it all evolves around. Okay, I think that's it. If you have any question,
just one. Just an easy one. If my database says person A is a friend of person B, and person A asked me for all the data I have, what am I even allowed to talk about person B?
may, in general, not hand out information on person B.
Not even their name, because that's information I have stored on person A.
That's exactly the type of cross-reference that I talked about earlier. Yes, that is a problem. So basically, you need to have a way to identify persons and exclude people from things. I doubt that is going to cause substantial fines or a lot of lawsuits, but it might. In certain cases, it actually might, because if you have a service like Tinder, or a service where you wouldn't want other people to know about you, then just imagine that someone asks for their data and by coincidence they figure out that on the weekend there's things happening that you don't want people to know about. Or maybe you do, but I would promote it differently if you did. So yeah, the cross-referencing is a big problem. I wouldn't know how to come up with a solution unless you use a specific type of database where you can divide entities and relations, which Andre could talk about too. I think, as far as I know, the graph database would be a good way to deal with it, which I know nothing about, but I've heard the name and I'm repeating it to you now. So technically you will probably have to have a way to separate entities from relations, but that's as much as I can give you at this point. So the question wasn't all that easy, really, Vyros. That's one of the aspects that'll be really, really difficult. Unless any of you has a really good solution, and approach me at the bonfire or outside or any way you want. Thanks very much. I'm glad that all you showed up here. Thank you. Stickers.